Thank you. You may go ahead, sir.
Chairperson, I thought I was not going to say these things. But as the inquiry continues, I felt, because my career is in jeopardy, I cannot just keep quiet. Let me raise my concerns for what it is worth. Maybe, maybe not, they will help, but they will help, naturally, they will help my conscience. Chairperson, to be honest, I find this process extremely unfair. I don't blame anybody here. I don't blame the presiding panel. I don't blame the evidence leaders. I don't blame anybody else. I blame the process itself. I blame the design of the process itself. For the following reasons. We were suspended based on an allegation made by an unidentified person or persons that we are unfit to hold office. And it is alleged that such allegations is of a serious nature as to warrant this kind of a process. The difficulty about all that, I understand because it's an inquiry, is the fact that other than the broad allegation that you are unfit to hold office, you are not told of on what basis. What are these issues that need to be looked at in particular so that you know what is the basis of this broad allegation by this unidentified individual or individuals. Now that makes my life extremely difficult. It makes my life extremely difficult to prepare for this inquiry. Up to the point of when this inquiry started on the 21st of January, I did not know what to expect, what to look for, what to prepare for. So that was a serious dilemma for me. The only time I came to know what is this that I must answer to is only when witnesses are called on the witness stand to come and implicate me. It is at that point then that I had to run like a headless chicken, going to look for evidence, information, documents to refute those allegations, which is very unfair. You simply don't know what to expect, what to prepare for. For example, is the question yesterday, the first question, or one of the preliminary questions by the evidence leader, about the examples of the cases that I dealt with in the commercial crime sphere. You know, that information is scattered all over, and unfortunately for me, it is not difficult to get hold of that information. I am like somebody who's engaged in a fight, but one of your hands is tied behind your back, which is a situation I find to be extremely unfair. I thought this inquiry would go out and collect all the evidence, not necessarily evidence that is going to implicate us, but evidence that is going to help the evidence leaders to determine whether in the whole conspectus of the evidence, it's able to make a determination either way. Particularly with reference to the case of Mr. Mdluli in my case. As I was being asked questions, something keeps on coming to the back of my mind. You know, I keep on talking to myself. I wanted to argue with the evidence leader, but I kept on talking myself. We are not there to argue. You are here to answer questions. But how do you answer questions when you know that the evidence that would help you to answer those questions is supposed to be in front of this commission? At least it would be better for you to answer with that information, all of it having been collected. I feel like I'm an accused person now as I'm sitting here. For example, Chairperson, one of the issues in the case of Mdluli is the allegation that we mishandled that case. It has always been in the public space that we mishandled the case. One of the issues relates, for example, to the question of documents. My reference to the Inspector General, the documents that were supposed to be declassified and all that. You know, I would have expected that that evidence should have been collected and became part of this inquiry.
Sorry that I'm disturbing you, Mr. Mokgoro. Let me just understand. What evidence did you expect to have been collected?
I would have expected the evidence relating to the role of the Inspector General, the evidence relating to the status of the documents in relation to the Mdluli case. For example, I would have expected that evidence should have been collected. I know that evidence, not necessarily in our favor, but I think it would have given the inquiry a broad view and understanding of the issues around this. Because I have this following information, which is in the public domain in any event. I know that the NPA has been requested by the prosecutors who were engaged after some time. This matter was struck off the roll sometime in July 2015. It was struck off the roll in terms of Section 342A. I know that the NDPP in the NPA was approached by the prosecutors who were subsequently requested to relook into the matter or to handle the matter. I know that the NDPP subsequently approached the Commissioner of Police to request the Commissioner of Police to help with the declassification of the documents in relation to Mdluli matter. That information is there in the NPA. Those letters, those requests. I would have expected that information is behind this commission. I know that the Commissioner of Police has consistently refused to accede to the request to declassify that information. That is a matter in the public domain. They are citing a number of reasons. I know that the Mdluli matter was subsequently handed over to the IPID. That information is in the public domain. I would have expected that information would have been gathered from IPID to understand what are the issues, what are the problems regarding this declassification. I don't have access to IPID. I don't have access to the National Commissioner of Police. I would have expected those people were contacted to get that information. I know that even IPID requested the National Commissioner of Police to declassify those documents. But I know that the Commissioner of Police has not done that because of a number of certain reasons. I would have expected that information is also collected and brought before this commission. I know that when IPID could not get assistance from the National Commissioner of Police, IPID then approached Parliament so that Parliament can intervene. That's public knowledge. It was debated in the parliamentary, that committee called SCOPA. I would have expected, for example, this commission to have gone to SCOPA and Parliament to find out what are the issues regarding this thing. Because all that information, Chairperson, is not helping me, is helping the understanding of the issues around this issue, which seems to be this big issue around the question of declassification of documents. Chairperson, I would evidence here before this commission is that, okay. Chairperson, sorry, my attorneys, my lawyer is saying I'm saying wrong things here. It's not the commission, it's the inquiry. I'm sorry.
I was going to correct you at some
Thank
stage.
you. Sorry,
Thank you.
Chairperson. Sorry, Chairperson. Chairperson, I know it's been the evidence before this inquiry that this matter of Mdluli was reinstated after several attempts. And this matter was subsequently struck off the roll by the Magistrate Court on the 6th of July, 2015. I would have expected that evidence from the Magistrate Court, that record of those proceedings should have been part of the evidence in this inquiry, so that that evidence would help the inquiry in its process of adjudication in this matter. Obviously, that evidence, Chairperson, would have led the inquiry to understand in the first place why was the case struck off the roll in terms of Section 342A. It would have helped the inquiry to determine why was the charge sheet why was the charge sheet in that matter embargoed. The fact is that that charge sheet has been embargoed. It has not been made public. Maybe the commission would have some persuasive to understand that. Why is that charge sheet embargoed? Why? Those are the questions. Another question would be, in that matter, as the evidence says, as the witnesses say, in any event, the other charge, the car transaction, the BMW transaction, it's complete, there's nothing. It would help the inquiry. Then if that is the case, why is it then that you could not separate that charge from the other charges if there's no requirement for declassification? That information, maybe, that is information I thought would help this inquiry. Furthermore, Chairperson, a lot has been said here about the powers of the Inspector General with regard to investigation. I've all along maintained that the IG, Inspector General, has got powers to do investigation, obviously not for criminal purposes, but in terms of their powers, as we have heard. I would have expected the inquiry to understand that, to go to the, for example, to the Inspector General to understand, more especially in the light of the fact that Inspector General has done that in certain instances, so that you understand in what instances do you do the investigations, in what instances you don't do the investigations, what is the criteria, why do you choose these cases, why don't you do other cases? For example, Chairperson, in 2014, the Inspector General issued a report to the Minister of State Security in respect of its investigation by the Inspector General into a kind of a situation similar to the kind of a situation that obtains in the Mdluli matter, the abuse of funds. The report, I don't have the report, but it is public knowledge. The report or the report about that would be found in the City Press of 19th October 2014. 19th October, it says, spies, the title is saying, spies plunder /fund. just a few paragraphs there. It reads, Intelligence Minister David Mokgoro has received Inspector General's report and says appropriate action would be taken. Further down, just one paragraph. Inspector General of Intelligence Faith Radebe has conducted her own investigation into the matter and has handed her final report to State Security David Mokgoro. Mokgoro has confirmed that he has received the report from Faith Radebe and would take appropriate and necessary action on the basis of her findings. And lastly, just one paragraph, Mr. Manzini and Mr. Fraser responded to detailed questions by City Press saying, we are aware of an investigation conducted against us by the Inspector General to which we have cooperated fully. The point is that this is an investigation done by the Inspector General. The question is, maybe there's a criteria they choose, but in any event, that is what I think I must just bring before the Commission. Almost finally, Chairperson, I would have thought when the evidence yesterday about the numbers was led, that it was a question of 7 against 1. 7 said there's a case, you are only 1 who said there's no case. I thought because the inquiry is not about attributing blame on me, it's about to understanding the issues as a whole. I thought maybe the evidence would go further and look at other evidence of what other prosecutors are saying. Because the impression created as we speak is that, Mkhwebi, you have done a mess. We see that there are 7 people, you are only 1. That is the impression. I got phone calls yesterday. There are 7 people, there's only 1, you are only 1. 7 says, you know, and even a journalist phoned me about that. That's how the people consume, because they take the information at face value. They don't have to research. This is what it says. You are wrong because 7 people, yet we know for a fact that is not the case. Only evidence. I would have expected that evidence maybe to be, I don't know how it will be done, but I would have expected, let's take a step further. Let's look at the reports of the prosecutors. At least 3, we don't have to go much. The prosecutors who subsequently evaluated the same matter as I did. What do they say? The reports of the prosecutors. For example, I don't know whether they are in the Dropbox or not. I've always mentioned about 8 reports and said the 9th is mine. I would have expected that evidence because this is a public, this inquiry is held in a public domain. I would have expected that a balanced picture is presented so that the public is given the fullest possible picture. Those reports of the prosecutors tell a different story to what has been portrayed here. They tell a completely different story to the extent that at some point I don't know whether I need to go, but the point is that there are those reports. I do not know. I want to place those reports. I don't know how to do it. I want to read those reports into the record, at least the 3 were, not all of them, 3 of them, a few paragraphs of those reports, so that that picture about that 7 against 1 is balanced. Chairperson, I think those were my concerns that I thought I need to raise before the cross-examination continues. Thank you very much.
Okay, thank you, Mr. Mkhwebi. I would like to give Ms. Bauer an opportunity to respond.
Madam Chair, I'm not going to dispute that this is a difficult process. And it is a process that commenced at a difficult time of the year, which made the collection of evidence difficult. We do not have subpoena powers. We cannot command a person to appear before the inquiry. We have made certain endeavors to get people to come and appear before the inquiry, and we've made certain endeavors to put information before the inquiry, both in written form and in oral form. within certain limitations, not everything can be led orally. And we have from day one had an arrangement that everything that was before the courts is evidence before this inquiry. Everything that is constituted and put into the Dropbox is evidence before this inquiry. Those very 9 reports are on the Dropbox, have been on the Dropbox for a considerable period of time, including Advocate Nomgcobo's very last report, which is, I understand, the 14th of July 2014 one. My question yesterday wasn't based on subsequent events. I was doing this chronologically at a particular point in time at the end of 2011 through to March 2012. There was no other prosecutor's reports available besides the proposition that I put to Advocate Nomgcobo yesterday. I'm not disputing that there are subsequent reports. It was raised in cross-examination by, I think, my friend Advocate Masuku raised it. The reports of Advocate Becker was dealt with when Advocate Mzinyati gave evidence. I stand corrected, but I think 4 of those reports had been raised in cross-examination of other witnesses. The report of Honor Asau, which is the one informing Advocate Abrams, or is here, or Advocate, the report of the prosecutors that informed Advocate Abrams is here. And as explained by both Advocates Ferreira and Advocate Rolofse in the evidence before this inquiry, the departing point was what was the difference in the charge sheet and the investigations conducted with the additional charges that emanated, for example, the trip to Singapore. None of that was before Advocate Nomgcobo in December 2011, and what we were exploring is his decisions. If I came across as being unfair in that process yesterday, I apologize, Advocate Nomgcobo, but I was looking at things at a particular time within a chronology going on. On the understanding that I accept what was led in cross-examination, that there were different viewpoints later, but that's evidence before the inquiry already. We cannot lead every piece of paper and every opinion that is before us orally. It is why with Advocate Jiba led the evidence on the understanding that the affidavits is evidence before the inquiry. And we accept that. So I'm not sure how to take this process forward or how to understand that Advocate Nomgcobo had not even known that those reports were there. We accept not everybody's Dropbox literate. We have extended assistance when asked on whatever occasion asked. We have offered to give documents on email. We have said we'll copy for you if you want. When those requests have been made, we have accommodated those requests. We do not know what Advocate Nomgcobo's legal advisors provide him with or not. I can't take it further than that.
Ma'am, sorry.
Maybe,
Sorry.
okay, before I ask you the question, Mr. Rib?
Ma'am, if I can just, I know it was during cross-examination. It's correct that the reports which are being referred to are in the Dropbox. We in fact prepared a bundle, I think, before the cross-examination of Ferreira, if I'm not mistaken. But now it's already getting a while ago and a lot of water has gone under the bridge. And those reports did emanate from Advocate Nomgcobo himself. All I can ask, and I would ask the panel to consider, is Advocate Nomgcobo is asked now to have insight again into those reports, and if we could just be given an opportunity to supply him with the reports so he can finish making whatever it is that he wants to make to the, because obviously we're not aware of what he's doing because he's under cross-examination, and then I assume Advocate Barber can continue with the prosecution with the cross-examination of Advocate Nomgcobo when he's, I'm sure it's not going to delay matters very long. Sounded like he was at the end of his presentation. Thank you, ma'am.
Considering that we had planned to complete Mr. Nomgcobo's cross today, how long do you think it would take?
No, not very long. The reports are all somewhere here. We will just quickly find them again. They were in a bundle, all put together chronologically. So if we can get 5-10 minutes to lay our hands on it and put it before him, then he must put before the panel whatever it is he had in mind, if that's in order with you.
Mr. Mokgoro, you're burning to say something.
Chairperson, I do have the reports right in front of me. My point is that these reports, I understand what Advocate Bauer is saying. The point is that the impression that is left in the mind of the public, that information is not part of that narrative. I do have the reports in front of me. I want opportunity to go through those reports and read them into the record. It's not going to take much time to do that, Chairperson. I refer only to 3 reports.
Yeah.
One of them could be a one-liner, for example.
Okay, so you confirm what your
Yes, yes.
council is saying?
Yes.
Okay. Any objection?
Madam Chair, Advocate Mokgoro is in the middle of cross-examination. May I suggest,
Yeah.
let me finish and let his counsel then take him to that in re-examination. In the same manner when Mr. Hofmeyer wanted to raise concerns which didn't fall in Advocate Arendt's cross-examination with the panel, and the ruling was it must be dealt with in re-examination, and I fairly gave Mr. Hofmeyer an opportunity to do that, and I'm no difficulty if Advocate Mokgoro wants to put that before the inquiry in that manner. I have no objection to it. I'm simply saying can we follow a process
In terms of the rules
uniformity?
of cross-examination, the basic principles of cross-examination. So while you're under cross, I agree with Ms. Bauer that we might want to complete your cross. And then in re-examination, Mr. Rip can take you through the reports. By then, we hope you would have, we'll give you an opportunity to read the reports, okay? Yes.
Thank you, Chairperson. I understand. Thank you.
Thank you. Can we then proceed? Ms. Bauer?
I want to pick up where I thought I left off yesterday, but we were going around a little bit. So let me just encapsulate that I had put to you, and maybe in summary, that it is reasonable to assume when somebody's car is being disposed of, that papers need to be signed, and ownership is being transferred, that a person would have reasonable knowledge of that. Would you agree with that?
I definitely would not agree with that.
To take you back to the consultative note that we were discussing yesterday, which is at page 68 of the bundle. And I simply want to draw your attention to the last line in that paragraph where you actually point out that you had I had put to you yesterday rather unfairly, based on the date that you had received the representations from Advocate Smith and Breitenbach on the 30th of November, but I see detailed in your own report, you point out that the report was received on the 4th of December. And I don't want to mislead you by having led you into something else. It's paragraph 8 on page 71. I had put to you that it's unlikely that you had worked on a Sunday, but if you'd received the reports on the 4th of December, which was a Sunday, then your version is probably correct, and I had put the proposition to you wrongly. This was in the context of the dates we were discussing. Do you see that, Advocate Nomgcobo?
Chairperson, I see that, but I don't know how it could have been the 4th, because the 4th was a Sunday. You know.
It's emails, Advocate Nomgcobo. one can receive and open up the email when you get it on any particular date. But I take it now further than that, I simply had put the proposition to you which isn't based correctly on the documents, and I was correcting that. Now in paragraph 11, I just want to be very clear on it. I took you quite extensively through what Advocate Smith indicated to you. Do you stand by what you say in paragraph 11, that the prosecutor's report does not add value to what is already in the representations?
I stand by my statement in that regard.
Did you ever discuss this with Advocate Smith?
I did not discuss that with Advocate Smith. I only expected a report from Advocate Smith.
Do you see in paragraph 12, you point out that if you turn the page, you couldn't actually fathom why he was arrested because his role does not appear evident from the documentation in the docket. But in paragraph 12, you acknowledge that there is a loan agreement entered into between him and Jan Venter of Atlantis Nissen. Do you see that?
I see that. That's exactly why I raised that question.
Did you have regard to what section 2 as read with section 10 of the Poker Act says about loans, the reasonableness of knowing, and the criteria in which one uses when one looks at the elements of the offense?
Now, Advocate Bauer, you are confusing me. You're talking about poker.
Sorry, I'm talking about the you know which act I'm talking about, the one that contains the section 10.
Yes, sure.
Yeah.
The-
Sorry.
Let's call it breaker. Let's call it breaker.
Yes. You confuse me, you prosecutors, with all these. Okay, I call it the Corruption Act, but that's probably not right either. And that act has a special interpretation which sets out what is deemed for a person to have knowledge. That the person believes that there's a reasonable possibility of the existence of that fact as being sufficient for knowing. I'm going to leave this question till after we take an adjournment and you have a chance to look at section 2 and not labor on this point. But in essence, your view was that there was nothing unlawful about this loan agreement from what you could ascertain from the docket. Correct?
The mere fact that there's a loan agreement does not prove an offense because the offense relates to unauthorized gratification.
Must one read in paragraph 15 that you accepted that a crime was committed, but that your point of departure was that you couldn't link Mluli to that crime?
There was a suspicion that a crime was committed. As I'm saying, because the car is Mluli's car, it is sold, and there's a shortfall of 90,000, which you are supposed to pay. There's no evidence that it is paid. But the problem in this case is Mluli is nowhere. His fingerprints are nowhere to be seen in any of the documents. They are done on his behalf by his colleagues. So on that, amongst others, on that basis, I don't see how you could even say there's a prima facie case against him. There's a suspicion indeed. I'm still very suspicious. If this matter was investigated, I'm sure something would come out.
Even his signature on the acknowledgement of debt?
That is still a problem. The investigators could not determine whose signature that is. The evidence is that although it is his car, nobody could say whose signature that is. It's not his signature according to the investigations. It's not his signature. That is the real problem with this case. Now
you question the conduct and the good faith of the magistrate. You raise that as a difficulty within the memo, and you say that is the subject of a separate inquiry that you don't go into at this stage. Do you ever go into it?
Look, Advocate Bauer, you know, as prosecutors, when we communicate amongst others, we don't communicate with the expectation that your information is going to be public. We communicate with freedom, all freedom. We say also, like if we read judgments, we criticize judges, we know in the comfort of our offices. We don't have an expectation that this information we're saying about this not so good things we're saying about this judge or this magistrate will find into the public. Because, I mean, we don't discuss with that. Otherwise, there will be no freedom of expression within the office if we were to be constrained about information. That document was not written with the expectation that I was just raising my concerns internally.
But that doesn't answer the question. The version on the table is Breitenbach has to go off and investigate. If she finds the evidence, matter gets enrolled again. But if you have genuine concerns about the warrant that has been issued by the magistrate, then surely those are concerns that must be dealt with before you even re-enroll. Do you agree with that?
There were the side issues for me, you know. I did not, it was not necessary to follow them. I did not follow them any further. I don't know whether I agree with you or not.
If you look at paragraph 23, and you've heard what Colonel Rudolphs had to say, would you agree that you were incorrect in relation to the search warrants? That in fact there was consultation with Advocate Samalani at that time, and that in fact they didn't use the search warrants, they got the documents by agreement?
What is the question? Can you...
Look at paragraph 23 of
Yes.
your note. You conclude there, the investigator and the prosecutor in this matter should have appreciated and realized this difficulty when police could not serve the search warrant, which according to the regional head was prepared after discussion with the National Director of Public Prosecution. It appears they did not, and neither did the regional head. And I read that as saying that there wasn't a discussion with the regional head or the NDPP. And in fact, when Colonel Rudolphs had testified, he talked about the extensive conversation that had occurred between senior management at the NPA and SABC, an agreement that was concluded, and a person that was designated as the point person for purposes of giving the documentation. And Colonel Rudolphs was very clear, we did not get this pursuant to a search warrant, we got this pursuant to an arrangement that was reached.
I heard this is what he said.
So if Colonel Rudolphs is correct in that regard, then you are incorrect in paragraph 23 of your note. Would you agree?
I am not so sure whether I am, because my view in this matter as a whole has always been that we have to be extremely careful here. I have experiences from my previous position as in the DSO. I know how these things turn out, more especially if you deal with intelligence community.
Advocate Mokgoro, my question was a simple one. If Colonel Rudolphs was right, then the averments in paragraph 23 would be wrong. Do you agree with that?
Let me reread paragraph 23. Well, I think I might have to concede.
Now, if you go to paragraph 24, and I'm skipping paragraph 24 because I think there's an error. There's no section 8.1 sub 1 in the Act, but I don't think anything turns on it. It's just an error, which we all make from time to time. If we go to paragraph 25, I want to be very clear that I'm not interpreting this wrongly. You are not suggesting that the provisions of Section 77C8 trumps the Constitution. That's not what you're saying. Is that correct?
That is correct.
And so, must one read Section 25 as saying you want them to defer this criminal investigation until such time as the IGI has completed its investigation?
That was not my intention. My intention has always been, the manner we obtain our evidence should always be beyond reproach. We must ensure that we comply, obviously in line with the Constitution, with all the laws of the country. We must ensure that everything is done properly. That was the intention behind. Maybe my language, phrasing of the language is not that strictly maybe correct.
But you would agree when you say refer members of the crime intelligence to the IGI with the information that they've come to you for, and then expect the Inspector General, who would have investigated the matter and advise if there was any reason to pursue criminal investigation, doesn't necessarily correlate to what you intended to convey. Would you agree with that?
My intention is based on my reading of Section 77CA. Sorry. Chairperson, sorry. Chairperson, I apologize. I forgot that my phone is in my pocket.
Apologies
I
accepted.
apologize profusely,
Yes,
Chairperson.
apologies accepted. And may we kindly ask all,
I normally switch
Of
it off,
us, yeah,
Chairperson, all the
to-
time. I forgot.
yes, all of us
Yeah.
might want to switch off our phones.
The seat was
Okay.
too hot. I forgot, Chairperson.
I know.
Yes.
I would never put you in the hot seat.
Advocate Bauer is grilling me here.
I would never do that. I have no prosecutorial training, unfortunately. I had omitted.
Tell us when you're ready, Mr. Mokgoro.
Chairperson, I'm trying to switch off this.
Your phone is too sophisticated. Does it take so long?
Chairperson,
Do you want that
no.
young lady to help you?
no, it's done, Chairperson, it's done.
Oh, okay.
I apologize.
No.
We won't tender Mr. Masuku's services.
We may proceed, Ms. Bauer.
Right. I had omitted to raise with you paragraph 16 of the memo, because my interpretation of paragraph 16 is when you say the evidence in the docket as well as the report of the prosecutor do not seem to help in the matter. The state of affairs leaves one with a number of questions about how both the investigator and the prosecution handle the matter. Are you casting aspersions on the prosecutor specifically, with some ulterior motive behind it, or are you simply looking at it from a competence completion point of view?
Chairperson, there was no intention to cast any aspersions on anybody. Usually when we raise queries like in the docket, you always do so sometimes as robust as you can so that the message is understood. But there's definitely no intention to cast aspersions on anybody at all.
But you do suggest in paragraph 26 that the manner in which they went about it was a possible breach of the security legislation.
That was my concern. That was my concern because I was concerned. We have handled these situations. I had experience of this situation previously. So I always approach situations like this with extreme caution. Maybe I was too cautious because of the previous experiences. I know in the past where we had a situation where the Scorpions wanted to search the same offices. It was almost and wanted documents from crime intelligence. So I am aware, I've got experiences around these issues. I was a bit too cautious maybe.
You see, what concerned, what I couldn't quite figure out, precisely which security legislation were you saying they were breaching? Or did you have in mind that they were breaching?
Advocate Bauer, I keep on referring to Section 77CA, capital A, because in terms of that section, it's written that the Inspector General's functions, among others, is to do those things, receive complaints from members themselves. If the members in crime intelligence had concerns that their colleagues are stealing, their colleagues are enriching themselves, their colleagues are committing corruption, they've got an easiest way to deal with that, to report those things to the Inspector General. That would be the easiest, because it helps us with issues of admissibility of evidence, because at some point in time you have to deal with issues of admissibility, because that information, strictly speaking, we're talking about privileged information, state secrets. Let's rather be correct from the beginning of our matter. That was my intention around this.
So your interpretation of Section 7 cannot mean that the only party that can investigate this is the Inspector General. You would agree with that?
I don't suggest that for any moment.
You would also agree that that is a function of the Inspector General in that section, and that when a crime investigation goes on, it cannot constitute a breach of that section.
Can you repeat the question?
Well, if the Inspector General doesn't have exclusive powers, then if SABC performs their crime investigations, those cannot be done in breach of Section 7.
Naturally, if their evidence would relate to state secrets, privileged information in the crime, or rather in the security environment, obviously his or her assistance might at some point in time be required.
But that doesn't constitute a breach of the law by itself.
You know, my reference or my concerns about that is the conduct. What is this that these officials of crime, why would these officials of crime intelligence not take that information which was a concern to them, constituted those irregular or those transgressions? They have got an easiest way. You know, why is it they have to give it to outside parties? That is going to create problems for you as a prosecutor at the end of the day. You are going to be in problem. You can't produce that evidence in court.
I'm not entirely sure I understand the proposition, but it seems to me that you are suggesting that because you're a member of crime intelligence, you cannot lay a complaint of a crime that is being committed with SABC. You must go to the Inspector General. Because if you don't do that, you make the life of the police difficult.
I'm not suggesting that, but I would have thought that is the easiest way to make my life as a prosecutor as easy as possible. I don't have to battle with issue of, privilege, with issues of the process of declassification.
Now, you know that by the time you met with advocates Breitenbach and Mzanyati on the 9th, they had already met with the office of the Inspector General on the 8th, and they were told that they were not going to do this investigation. Do you recall that?
Yes, I do recall that. I recall that we also had an intensive or extensive discussion, and at the end we agreed that the assistance of the Inspector General might be a requirement.
And you also then received the letter of the 19th of March, which is on page 109 of the bundle, from the Inspector General, 3 months after this meeting. correct?
Yes, Chairperson, that is correct.
Right. So by the 19th of March, this letter comes. Now you testified and you were asked about this in the disciplinary proceedings, in Clinus Breitenbach's disciplinary proceedings. Do you recall that?
Yes.
Right. Now these disciplinary records are to be found in the Dropbox. It's under H, number 3, and if I recall correctly, you gave evidence on the 23rd of January. So it would be 3.4. And I want to take you to page 2872 of the transcript. The transcript number is 2872. And Advocate Mokgoro, you will recall that during that hearing, Advocate Trengrove in cross-examination handed up a document to you dated the 2nd of March 2012. And I'm going to give you that document, which formed part of the bundle in the disciplinary proceedings.
If I may ask a question, I got a document dated the 2nd of March.
2012 at the disciplinary proceedings, which took place in January 2013. And your evidence there was that this was the first time in the disciplinary proceedings that you saw that document, and you make that statement in the disciplinary inquiry at page 2872 at line 4 and 5. And I'm not disputing what you said there, that you were seeing this document and you were being provided this document for the first time during the disciplinary inquiry by Advocate Trengrove. I'm not sure if your colleague sitting next to you has got the page. It might be 3.3. I might be on it's the 22nd of January. I've misled you. It's not the 23rd. So it's 3.3. Sorry, he testified. I simply want to take you not so much to the transcript, but to the document itself. And what this document showed, and what you conceded in the hearing when it was put to you, was that it effectively showed that prior to your December meeting with advocates Mzanyati and Breitenbach, that the Hawks had in fact been liaising with the Inspector General throughout the process. Do you recall that?
I would not dispute that, although I don't recall.
The document that I've just handed up to you, and so that we have it for record purposes, I want to take you to paragraphs 26.
Then don't you want to identify the document?
The documentation, the document is a document dated 2nd March 2012, directed to the Commander Anti-Corruption Task Team, and this version is unsigned, but it emanates from K. Rolofse. If one looks at paragraph 26, and I'll tell you which specific paragraphs confirms that, it effectively says that the allegations was contained in a file and it was handed over to the Office of the Inspector General on the 17th of August 2011. Do you see that? In fact, the Inspector General
Yes,
personally got it on the 18th of August.
Yes, I see that.
Right. Now I take you to paragraph 2033 on the next page. We see that the Advocate Similani asks for a briefing specifically because of a request from the Office of the Inspector General. Do you see that?
I see that.
If you turn the next page, you see on the 20th of September, on the top at paragraph 35, the investigative team was informed by Lieutenant General Drummond that he was informed in writing by the Office of the Inspector General that they will not be attending to the report given to them on 18th of August, as a report of this nature can only be referred to through the Minister of Police. Do you see that?
Yes, I see that. I see that.
If you go to the next page, you will see that, in fact, the Office of the Inspector General requested copies of the search and seizure warrants that was supplied to them on the 24th of October.
I see that.
Right. And the background to that, which you don't necessarily see from the document, is that General Mluli lodged a complaint with the Inspector General, which one sees in other court proceedings, which is also on the record, which emanated in the Inspector General looking at it. If you go to paragraph 44, you will see that Majors General Henkel, de Kock, Jacobs, and Brigadier van Graan briefs the Inspector General to inform her of the situation developing at Crime Intelligence relating to the secret service account. Do you see that?
Yes, I see that.
If you go to paragraph 46, and maybe while I'm at it, if you look at paragraph 45, you will also see that they met with representatives of the Auditor General's office. They were briefed regarding the allegations of criminal conduct. They were requested to form part of the investigation, and they indicated that they do not wish to be part of the investigation. Do you see that in 45?
Yes, I note that. I see that.
Right. If you then go and you turn the pages, and you see at 67,
Come again.
67,
67.
after paragraph 67.
Oh, paragraph 67.
Sorry, my apologies. I've been giving you paragraph referencing all along. My apologies. You will see that on the day the matter is provisionally withdrawn from court on the 14th, the investigating officer meets with Advocate Breitenbach to consider the various options open in respect to the investigation. They again go and approach the Inspector General and the Auditor General in an attempt to include them in the investigation. And you would agree that that would have been pursuant to what you and Advocate Mzanyati and Advocate Breitenbach discussed. You accept that?
Yes, I see. This is what it says.
And it records that Advocate Breitenbach had on several occasions spoken to Advocate Govender by that stage. And it was each instance that she had done so, it was made clear that the Inspector General does not have the capacity and or the mandate to do a criminal investigation. Do you see that?
Yes, I see that.
If you go to paragraph 68, Colonel Roelofse himself goes the following month and he goes and speaks to Advocate Govender and says that SABC must make a formal request to the inspector regarding assistance, and she says that there was no consultation with you when you had made your decision, that there must be consultation prior to the withdrawal. That's recorded in paragraph 68. And you accepted that before you had taken your decision, you had not consulted with the Inspector General, correct?
Quite correct.
If you go to paragraph 69, you will see that Colonel Roelofse goes back to the Inspector General's office. He speaks to somebody else, Carl de Betso. And they make it clear to him that the responsibility to investigate crime lies with SABC. He advises SABC through the office of the Acting National Commissioner, Lieutenant General Makanazi, must make a formal request to the Inspector General regarding assistance. Do you see that?
Yes, I see that.
That's in January. In paragraph 91, and you will see that the investigation team was informed that Major General Lazarus has approached the chairperson of the Joint Standing Committee of Intelligence, Cecil Burgess, on various occasions without notifying his actual division head of these visits. Major General Lazarus is trying to convince Burgess that this investigation comprises national security. A letter from Burgess stating that Henkel must be removed from the investigation was sent to the acting divisional commissioner of CI. The investigation team had insight into this letter. Now, there is clearly an attempt to stop the investigation. Do you see that?
Where do you see that?
In paragraph 91. Lazarus goes to the Joint Standing Committee.
I don't know whether that means an attempt. I don't know whether that means an attempt to stop the investigation.
Fair enough. We'll go to that step further later. But essentially, there were indeed efforts, and you conceded that in the disciplinary inquiry, on the part of both Colonel Rolofse and Advocate Breitenbach to engage with the Inspector General's office and the Auditor General's office. And that culminates in the letter which then gets sent to, on the 19th of March, which you receive undercover from Lieutenant General Dramat from, I think it's, Commander Makanazi, where the Inspector General makes its position clear to SABC. Do you see that? And that's the letter of the 19th of March, to which specific reference is made to your memorandum, where it's made clear in paragraph 2.2 that any investigation conducted by the Inspector General is for the purposes of intelligent oversight, which must result in a report containing findings and recommendations. The mandate of the IGI does not extend to criminal investigations which are court-driven, and neither can the IGI assist the police in conducting criminal investigations. That rests solely with the police. I accept, Advocate Mokgoro, that your evidence to us is you don't agree with that, but I'm putting the proposition to you that that was what was relayed by the Inspector General on the 19th of March.
I accept that.
Right. Now we come to the 20th of March story. In fact, in the disciplinary inquiry, Advocate Trengrove asks you specifically, did you take this up with the Inspector General at all? And your answer is to be found at 2846, 2847 of the transcript.
Yes, I said no.
Do you recall that? You said no.
Yes.
And in fact, you offered an explanation as to why you didn't take it up. And the gist of your explanation, which I'm not necessarily going to read, but the gist of the explanation was essentially that you had a difference of opinion with the lady, the legal advisor at the IGI, which I understand to be Advocate Govender. Do you recall that?
Yes.
And that you confirmed that you had met with Advocate Govender, and your evidence was to that effect that you had met with her on the 20th of March. Correct?
Correct.
And that meeting was, I understand, roughly about an hour, hour and a half.
Could have been around about there because it was quite extensive.
Yeah. Now, when you gave evidence of this, you appear to have exasperated Advocate Govender, because we were then met with an affidavit yesterday from her, which I provided you with a copy thereof yesterday.
Yes, it appears I did, and I apologize if I did.
Well, I'm not the one that must get an apology, but it does appear from the affidavit that the gist of what was discussed at the meeting based on Advocate Governor's affidavit and your oral evidence before this inquiry is different. Do you agree?
Let me just say I don't agree with Advocate Governor. I don't agree with Advocate Govender for the simple reason that, I understand her denial, because I think she gave me more than was required. I did not say all the things that she gave me. I gave a sanitized version, because there are a number of things I thought I cannot say in a public forum like this, because those things were said in confidence. So I decided to give a sanitized version. I understand her denial, and despite her denial, I will not disclose the other things that we discussed together with her.
But essentially, Advocate Mokgoro, her version is consistent with the version that you had put up before the disciplinary inquiry as well. That there is nothing in the disciplinary inquiry evidence where you said we had discussed the merits, that I had told her about the docket. Effectively, you had said that we agreed to disagree on the law. At a certain point, she requested me to do certain things of ensuring that the case is reinstated. And you make no mention there as well of any other information.
You would notice that I mentioned certain other things which has to be done, and she could not have requested me to ensure the case is reinstated unless we would have discussed the contents. We discussed the merits of the case extensively. We did.
I'm simply putting to you that her version is that there was no discussion of the merits.
I
And
dispute
in
that.
fact, there was no discussion of the legislation governing the IGI being amended, and in fact, to date, 8 years later, there are no amendments to that act. And she disputes what you had said here in evidence.
That's fair enough. That's fair enough. But the point is, we discussed the case, we discussed the merits. I did not just take it from anywhere, this thing about we want to align our mandate in line with international best practice. Those were her actual words. And we went on to talk about other information that she gave, which I'm not prepared to give. We said all those things.
But by the 20th of March, and you can accuse me of number crunching again, by the 20th of March, you are again on one side of the spectrum, and on the other side of the spectrum, you have the Inspector General, the legal advisor, Breitenbach, Ferreira, Mzanyati, and General Makonazi and Dramat, you are the only one insisting on the Inspector General conducting an investigation.
You know, Chairperson, I would say, Advocate Bauer, if you understand the spirit of my those suggestions, it's not to say the Inspector General conducts criminal investigation. Throughout everything I did, I emphasized the question of access to documents. I'm saying all these things because I want us to avoid a situation where we find ourselves where we would be accused of breaching privilege, breaching state privilege. Let's rather do this thing as clean as possible from the beginning. I had a responsibility to protect the integrity of the NPA. So all these things I was doing, it was for that purpose, to ensure that we are on the cleanest side as possible. Unfortunately, if some other people see it differently, I can't say more than what I've said.
Now, these further investigations that was contemplated on the meeting of the 9th of December, those related to the IG and the AG. Do you accept that?
Sorry. I don't know what you mean when you say they relate to the IG and the AG. They relate to the evidence in the matter, which evidence could be obtained with the assistance of those bodies, the AG and IG, not that investigation related to the AG or IG.
In the disciplinary inquiry, you were asked the proposition was put to you that Advocate Breitenbach's instructions on your version was twofold. Instruct the prosecutor to withdraw the case provisionally and to instruct SABC to do those matters that were identified to ensure that the matters being enrolled. But nowhere do you point to what those matters precisely were, and when you were asked, you identified them. You identified as what needed to be done was for SABC to approach the IG, and that is at 2893 of the transcript, whereafter, with the IG's assistance and the documentations from the IG, and if they got it from the IG, it could be enrolled, I understand it. And you also indicated that when you wrote your memorandum on the 4th, you are of the view that it should be investigated by the IG and not SABC, but you were persuaded that SABC could indeed investigate the matter. Do you agree with that?
You've made a long statement. I don't know which one must I agree with, but
Let's break it up. Advocate Breitenbach's instructions was twofold on what you had testified in the disciplinary inquiry. First, to instruct the prosecutor to withdraw the case provisionally. Do you agree?
that was the results of the that was the result of the discussions during the meeting.
Secondly, to instruct SABC to do what matters were identified and to re-enroll the case.
To instruct the police to do the necessary investigation, as we identified during the meeting, with the assistance of the Inspector General, if that was required. That's what we discussed. And Advocate Breitenbach also suggested the Auditor General can also assist for forensic audit purposes.
You see, you then later asked to identify what was this that SABC needed to do. Do you need a break, Advocate Enquiry?
Okay, sure, thanks. You will take a break? Okay, thank you. For 10 minutes. Thank you. Mr. Mokgoro, you ready? Okay.
Yes, Chairperson.
Okay, thank you. Ms. Power, we're still in your hands.
I was putting a proposition to you that what had emerged from the meeting of the 9th of December was essentially two acts that Advocate Breitenbach had to do. One was to tell the prosecutor to withdraw provisionally, and two, to instruct SAPS to do those matters that were identified in the meeting of the 9th of December for purposes of obtaining that information to re-enroll the case.
That is correct.
And I wanted to put to you that you identified what those were in the disciplinary inquiry by saying that what SAPS needed to do was approach the Inspector General either for them to investigate or, as you understood it, to assist us to the point where they can direct us where to investigate. That was your understanding.
That was some of the things I said.
And I'm putting to you that when this was put to you in the disciplinary inquiry, that is how you answered the question. And then paragraph 30 of your affidavit in the full matter, let me be fair, you say the following. We close the meeting on this understanding that Advocate Breitenbach would request the police to obtain the outstanding information, documentation, as well as the relevant reports from the AG and IG so that the matter can be re-enrolled.
That summarizes there.
Second part of the very long proposition that I was now breaking up for you was that you conceded in the disciplinary inquiry that you had shifted from the position that only the IG could investigate, and you accepted and you'd been persuaded that SAPS could indeed conduct the investigation.
We discussed the matter extensively, and as part of the of the agreement that the matter must be further investigated, a suggestion was also included as part of that, that the IG should also be approached to assist, and the AG, Auditor General, should also be approached to assist.
Now, fairly, Advocate Breitenbach's evidence before this inquiry was that you did not give her an instruction to investigate further, and that as far as she was concerned, that she was reporting to Advocate Mzinyati, and you were not in a position to give her any instructions. And I must put it to you that she later on in cross-examination accepted that it was SAPS that was going to be given the instruction to investigate and not her. Do you agree?
Yes, I agree, because the discussion was that he must ask the police to do the necessary.
Who's he?
Chairperson, I'm very sorry, Chairperson, I'm very sorry. She was going to approach the police to do the necessary in terms of the...
That is the IG, the IGI.
No, Advocate Breitenbach.
Breitenbach, yes.
Essentially, when you explained this in the disciplinary inquiry, your motivation was that you wanted a better case to be built against General Mluli. Do you agree?
Yes, essentially that is so, because my concern was always the question of admissibility of the evidence. Whether that evidence is ultimately used or not, but the question is the admissibility aspect, the admissibility issue.
Right. Now I want to take you to your letter. We were on the timelines of you had received this letter from you had received the letter from General Dramat, to which the information from the Inspector General had been included. Sorry, I've just lost my place. Just give me a second. There is a letter dated the 27th of March in the bundle, and that letter is to be found at (114). Actually, if I And this was your response to Advocate Breitenbach after you had received the letter from General Dramat, correct? She had hand-delivered that letter to you, and you responded with this response, correct?
Correct.
Right. And you had testified that you were not happy that this letter had gone out of internal circles, correct? That your consultative note had been provided to the Inspector General.
I was not happy with that.
In fact, you took her to task on the third page of your letter, asking her what authorization she had under Section 41(6) of the NPA Act to disclose it, correct?
That is correct, Chairperson.
And I understand Section 41(6) is that you're actually not permitted to disclose information that comes to your attention in the course and scope of your employment without the consent of the National Director of Public Prosecutions.
Yes, that is correct, Chairperson.
You also then indicated yesterday that you had addressed the letter of the 30th of March to General Dramat, and you accepted that. I think the words you used, that the language was a bit harsh.
Yes, indeed.
What then arose next was that Advocate Breitenbach's memo landed. It was delivered to your office, the memo of the 13th of April, dated 13th of April, and it came to you roughly on the 24th of April. And you respond to that on the 26th of April.
Yes,
Correct?
I recall that.
And you confirm in your letter. Your letter of the 26th of April is to be found. Why don't one of you have the bloody index? At 143 of the documents. Correct?
Yes, Chairperson, that is correct.
Now, I'm sorry, Advocate Mokgoro, I should fairly have put to you a proposition on your earlier letter of the 30th. Can I take you back to page 117, please?
That's okay.
My apologies. On page 118 of your letter to General Dramat, you state in the last paragraph, this goes back to the matter is closed paragraph, but I want to, you stated in that letter, the NPA took a principled and considered decision on this matter without fear, favor, or prejudice, and it is required to do so in terms of the law. When you were here and I put to Advocate Mzanyati whether he regarded the decision of the 9th of December to be a principled and considered decision. And he responded that he did not, that effectively the decision was taken because you had already sent off the letter, and that effect, what had put them in that position was that they didn't want to send a prosecutor to court with instructions that differed.
I have noted Mzanyati's evidence in that regard.
Furthermore, it was put to him that when one says a matter is closed, one should take the English interpretation of it being closed, that there's nothing further that's going to happen in the matter. And if I can use the analogy, for instance, of the DPP office where I work, if we say we close the matter, we withdraw the file, we write on the cover close, and that the matter can go for filing, it is closed.
I don't want to take an issue with Mr. Mzanyati because that is actually like that, but once you say the matter is closed in the DPP office where I was as well, you close that file, you file it there. Police continue their investigations in that particular matter. Once everything is in order, the matter is again, at any stage, can again be put back on the roll.
You then, and I want to put the proposition to you, is that if we now turn to your letter of the 26th of April, what page was that? 143. Yes, keep yours open so I can get the pages. Right. If you see on the first page of the document, you record that it was directed to the acting NDPP, copied to Dr. Ramaiti, Mr. Hofmeyer, Advocate Mohatla, Advocate Mzanyati, and yourself. Advocate Ferreira and Breitenbach indicated that they didn't deliver this to Dr. Ramaiti and Advocate Mohatla because you had told them that you would do so. Do you have any comment on that?
I would not have said that I will deliver the letter to Advocate Mohatla. At least I would have said I would deliver the letter to Dr. Ramaite at the time, because my direct supervisor at the time was Dr. Ramaite, not Advocate Mohatla.
Prior to this, you had a meeting with General Dramat on the 1st of April, correct?
Yes, on the 1st I had met General Dramat.
And the difference, we'll come to the difference of opinion between you and General Dramat at the moment. But essentially, you had indicated that how you got to know about the Auditor General examining the information containing the alleged criminal transaction by Mludi and Barnard was because you had been informed thereof by General Dramat. Correct?
Yes, General Dramat mentioned that the account in respect of where this transaction fall was considered by the Auditor General, and there was nothing wrong that was found at that stage.
Now, do you accept that this Auditor General's audit of the Secret Services account is not in the public domain?
I wish I could understand. Can you repeat the question? I think I missed
Sorry.
it. Sorry.
The Auditor General's report. The Auditor General submits a report for all kinds of government departments. You agree?
Yes, I do.
Its report in respect of the Secret Services account goes to the Joint Standing Committee on Intelligence. It is not issued in the public domain.
That is correct.
So the only way one gets access to the Auditor General's report is if it is declassified by the Joint Standing Committee of Intelligence. Correct?
Yes, only if one is given access to that or it is declassified.
In the disciplinary inquiry, you were asked about this letter of the 26th of April, which I now showed you. And it stems from the question of the knowledge you had at the time of writing this letter. And I specifically want to take you to page 3002 of the transcript. Which I think would be on the 23rd of January folder. And I want to take you to probably page 3000 first, so that we can see the context. Advocate Trengrove reads the letter of the 26th of April to you, and you confirm on page 3000 that it is your letter. It is your letter, correct?
That is correct.
And he puts to you that he'd like to start off with what you don't say in the memo. And he records that if your evidence in this hearing is true, that one would have expected that the first thing you would have said would have been that the memo was based on a misunderstanding. You're all for the prosecution, and in fact, all you're concerned with is to build a strong case, but that you don't say that in the memo.
This is what is put to me during the cross-examination.
And you then explain to him that one needs to understand this in the context of the letter. Do you agree?
Yes, I do.
In effect, what is challenging you about is the statement in the letter that it is not in the interest of justice for the NPA to be involved in this investigation. Correct?
Yes. Sorry. Yes, that is the context.
Right. And in the course of your explanation, I want to pick it up at what you say at paragraph, at lines 18 on page 302, where you say, in the course of all of this, whilst I thought the police was busy with the investigation, as I thought were instructed in the course of time, I received representations, Chairperson, from certain members of the crime intelligence on a certain matter which was related to this from 2 senior counsels from Johannesburg. You then proceeded to tell advocate or the inquiry chairperson, in the context of that, in the course of those representations I received, they referred me to information because these officials were together with them. They referred me to lots of classified information, some of which was already in the public domain, which they referred to me to that information, drawing me my attention to certain dangers around the environment around which these things are happening. In the course of that, they also referred me to what I regarded as a situation which, if proven true, would amount to abuse of legal processes. A certain prosecutor, I'll call him Prosecutor Y, for whatever reason got involved in the matter and even went to the extent of going to the companies or front companies that are related to this matter with threats that if they don't do A or B or don't cooperate, their businesses would be closed. There was a chilling story that was a chilling story for me to hear as a prosecutor. I said, why should we get involved in this matter in this fashion? Chairperson, after that, they give me the information about how, because it was one of the officials who visited me was a senior official from intelligence, gave me the information about the AG report and all that. And after that, I decided, Chairperson, because I looked at their representations, I found that as the NPA, there's nothing as far as the other people we can do about anything. Then I decided to go and meet a senior official of the Hawks, where I actually briefed the senior official of the Hawks about what is happening or with the information I received. And Chairperson, I briefed him, and he also, the official concerned, also made references to the difficulties they are having. We then discussed the issue, and agreement was at the end of the day the matter must be dealt with together with the AG. That was the agreement. So it was against that background that now we have taken a decision on the 9th. We are required effectively now, we are being required to breach our constitutional and legal duty to prosecute in circumstances where, or to institute prosecutions in circumstances where we are not supposed to. Sir, I felt everybody, whether his name is Satan or devil, I will not do that. It was in that context that I felt we are getting involved with this matter. It is not correct for us. That's the background against which I wrote this letter.
That is some of the background, yes.
Some of the background.
Yes.
Right. Now, you then later was asked, sorry, I don't want to, but it appears, Advocate Mzanyati, from your evidence that you in fact obtained this information.
It's definitely not Advocate Mzanyati.
Sorry, Choir Master. Advocate Mgwebi.
I've got many aliases, Chairperson. I'm also called Snail.
I have
My
not.
other alias is Snail, Chairperson.
Thanks for the information.
We haven't yet brought any garlic sauce, so I think we're safe. Effectively, from this evidence, it was apparent that you had obtained the information about the Attorney Auditor General before you had your meeting with General Dramat. Correct? You had been told about this by one of your crime intelligence visitors.
No, not really. I don't think so. I don't think so, because by the time I met Dramat, I had not heard that information. I met this crime intelligence official sometime in April after certain incidents, which I have not disclosed in that response.
You see, when you were asked to elaborate on this on page 3008 of the transcript, 3008 at line 12, you said, my concern was the NPA's involvement in this process and what was regarded as an illegal, unlawful or untoward activities. That was your concern at the time. Where Prosecutor Y would go to the extent of going to companies and making threats about what must be done. Was that your concern?
It was one of my concerns, Chairperson. As I'm saying, it was some of the context in that matter. And furthermore, it was in the context of the information that I received with regard to this matter and the things that were disclosed to me in confidence. One of the difficulties I was battling with in this matter, which I reported to a senior member of the Hawks, was to discover that around about April, I was under surveillance. I reported this matter to the Hawks.
Who did you report it to at the Hawks?
I reported this, the question of surveillance. I phoned General Sibia. General, what is happening? I gave him the description of the incidents, and he promised to look into this matter. Then I became very concerned about this.
Let me take you a step back. You had initially said to Advocate Trengrove that you had received representations in confidence by persons at Crime Intelligence. You did not want to name the persons, and you had not raised this with either Advocate Zimzanyati or Breitenbach.
Yes,
correct?
I did not.
You also indicated that you didn't go back to this Prosecutor Y, whom you had been told was involved in illegal activities.
Yes.
And you didn't raise it with him or her.
In the nature of things, in terms of how it was presented, it was such that this, although I had no way to verify, but from the description of the events and the way it is done, it was a bit chilling to me,
But you had no clear evidence that either Advocates Breitenbach or Ferreira or Smith had been involved in any improper activity.
No, it was not them. I will not name the prosecutor and the people that they were together with when these allegations were made. But the circumstances under which this was happening were such that it sounded that the NPA is getting involved now in things that are not within its mandate. We're getting our hands, in a sense.
And your sole source of information were these visitors that came to see you?
It was those visitors, and I also raised my concerns with more especially when it came to the question of surveillance, because I was not so sure what's happening. Okay. I also took it up with the Office of the National Commissioner at the time.
Now, can I take you to 3018 of your evidence? Where Advocate Reingrove says to you, and apart from the anonymous information, you invoke the Auditor General. And you answered yes. And he said, the Auditor General examined the information containing the alleged criminal transactions by Mluli and Barnard and found nothing untoward with the transaction. And he's now quoting from your letter of the 26th of April on the last I think it's there. And Advocate Reingrove asks you the question, who told you that the Auditor General had done that investigation? And your response to him was, a senior intelligence official who happens to be a chief. I think he was in the rank of a chief financial something. You mean of crime intelligence? And your answer was of crime intelligence. Do you see that, Advocate
Yes, I see
Mokgoro?
that.
And it was in that context that I put to you that you did not get this information about the Auditor General from Advocate General Dramat, but that based on your evidence, your own evidence in January 2013, you got that from your visitors.
The difficulty is that my visitors came, it was during April, that when my visitors, mid-April, somewhere there, you know. It was some time in April. I even had a file, although I did not have all the, because they did not leave any document with me. I was just taking notes. I had a file in the office. Unfortunately, I don't have it now. It would have shown me the date of that meeting.
We'll come to that in a moment. I want to take you in the freedom under the law matter. You provided written reasons for your decision. Do you recall that? It was dated July 2012.
I think I do.
Did you write it or was it written for you by counsel?
There I was requested to provide reasons. I drafted something which I gave to, I think I gave to the Legal Affairs Division. If I'm correct, it must have been Mr. Chita, then who would have taken that to counsel.
Can I hand you a document? And I must be honest, it is on the Dropbox. Actually, I don't know where it is on the Dropbox, but it might just be quicker. I just want you to confirm with me whether, to the best of your recollection, this was the document you had provided to the legal representatives. It's dated in March. I'm told it's Dropbox J11, 111. And from that, the final submissions, which was dated July 2012, was drafted and put before court, which you then signed. I could hand you up the signed version as well.
Yes, I see the document. I think I recognize the document.
So I'm putting to you that you provided them with a draft in March. They settled it, they finalized it, and you then signed the July 2012 version. The last page has got your signature on it.
Yes.
Hand up. Back, you on J 111, or else I'm going to be a bit lost in asking my questions from it. What is not contained in those representations is what the IGI's view was, and that they effectively refused to do an investigation, correct?
I can't recall now.
That it's not there.
Mr. Mokgoro, do you want time to look at it?
Yes, I think I do.
How many pages is it so that he can have a look?
First,
I'll hand, it's easier for you to read off a hard copy, so let me add the March version and the July version is essentially in the same terms. Would you prefer the one that you signed or would you prefer that one?
You know, I don't know, because I think there were many documents that went about July 2012 and June 2013. I don't know which, I just want to check.
This is the record that was filed at the High Court under the filing sheet which you signed as the record. Maybe it is better if I then provide you with the signed version to look at.
The 6 pages. This page there. I've done. I've looked at them. I've looked at the first. I thought I must look. You said I must look at the first 6 pages. Eh?
Sorry, of the July one, I'm particularly interested in paragraph 7 to 13 of the document. Sorry, the first 6, my apologies, Advocate Mokgoro, it's Friday. The first, the unsigned version was the first 6 pages, but the signed version was essentially paragraphs 7 onwards. And I had first put a proposition to you, was that essentially there was no mention of the communication from the IGI when you signed this in July 2012 that they were not going to be doing an investigation. Do you agree with that?
I'm trying to think if I did not mention that, whether I was supposed to mention. Let me agree, there was no contest. If there's nothing in this document, there's nothing.
Right. Now, in paragraph 7 of the document, you deal with, shall we call it the intelligence landscape, for lack of a better word.
I think that's a very elegant one.
Okay. And I just want to run through this without belaboring the point. You identified in 7.1.1 that it is a case governed by different rules, compliance measures, and accountings regime. Correct?
Correct. Correct, Chairperson.
You, in 7.1, in point 2, you deal on the next page with the uniqueness of the intelligence environment, And in point 3, you deal with the policies and procedures insofar as it differs in respect of the Secret Services account.
Yes.
And in evaluating all of this, you point out that the PFMA doesn't apply, and you refer to provisions of the Secret Service Act. Correct?
That is correct.
And you point out that when you assess the Secret Services account, it is not done according to the open procedures, but according to the closed procedures.
Correct.
Right. And you question in point 7 the measure about how you go about measuring whether the expenses are actually properly incurred or not. Correct? I am paraphrasing. If you disagree with my
that's okay.
paraphrasing,
Yeah, no,
tell
that's,
me.
That's fine.
Right? And you point out in point 8 that the starting point to determine wrongdoing would be to examine and assess the relevant financial statements. And you point out that the AG would have issued a report on these statements, which have been considered by the JSCI, which is the Joint Standing Committee of Intelligence, and it would have been reported to Parliament. So your point 10, you say without such a report, you can't determine whether there's a prima facie case. And that is why you want it. Let me quote it: in the absence of the AG's report, how does one, in the nature of the present matter, even begin to suggest the existence or otherwise of a prima facie case? And you then say that is why you thought the suggestion was a sensible one. Correct?
Quite correct.
You then, in the next couple of paragraphs, set out what you regarded as the applicable legal regime. And in paragraph 12, you make the point, at this point in time, it is a known fact that the expenses in the account, including the transaction which is subject to the police investigation, were undertaken and assessed in terms of the policies in place, and that these were reviewed and audited by the AG and considered by the JSCI. Correct?
Correct.
And you got that information from your visitors.
I got that information from my visitors, and I also verified it from other officials.
And which other officials did you verify that with?
I might have, during my visit to the Office of the National Commission, at some point when I was raising my concerns about the surveillance, we also spoke about this at some point in
Mokgoro,
time. Yeah.
the choir master speaks.
Yes. When I was raising my concerns about the question of surveillance that I mentioned, we also, because I was trying to understand what is happening around this case, so we also talked about that, and yeah.
You don't, in your representations to the court, in the review reasons, you point out in paragraph 22, let me not be incomplete on this, I should properly direct you to paragraph 22. You tell the court fairly that you received representations in confidence from other crime intelligence officers through their lawyers, and without going into detail, you point out that these representations clearly show that the expenses were incurred and reviewed and audited by the AG, which we've already dealt with, that the crime intelligence documents were illegally accessed by police investigation, that various members and persons, such as suppliers to crime intelligence, were subjected to threats, intimidation, and that they implicate Lieutenant General Mluli, and that Mluli's allegations of an ulterior motive and abuse find independent verification in these representations.
That is what I was told.
That is what you were told. You did not conduct any independent verification of what you were told.
No, no.
Now, I'm going to hand up to you. I have less conscience about making publicly known what is being told to you, and I'm going to hand up the document prepared by the legal representatives and the persons who made representations to you. And this is Ms. Zindralovic, who's the attorneys and the conveyances, and the representations were made on behalf of Major General Moodley, Major General Lazarus, Colonel Vanke, Colonel Barnard, Colonel Singh, and Lieutenant Sheikh. Is that correct? These were the people from crime intelligence.
Well, I don't know whether these are the same representations that I received, because I did not take any document with me. I wrote my notes, my own notes, which were in the file. I did not keep any document with me.
So these were provided to us from the NPA office. And I want to take you through the, can you recall that this was the name of the instructing attorney?
It sounds familiar.
Right. Do you recall that the people from crime intelligence who made a presentation to you included Major General Moodley, Major General Lazarus, Colonel Vanke, Colonel Barnard, Colonel Singh, and Lieutenant Sheikh?
No, on that day, there was two people I recall. I recall Lazarus. I can't recall that. There were two.
Right.
That I
And
recall.
you would know Lazarus to be the senior financial person at crime intelligence. In fact, he's since been fired and faced all kinds of procedures, correct?
That's correct.
And we know Colonel Barnard's name because he was one of Mluli's co-accused, correct?
Yes, correct.
Right. So let's go to the letter. And so that I get the record right, this letter is dated 31st of May 2012.
The 31st of May, it cannot be, because
30, no, the letter is dated the 31st of May 2012.
unless it was sent subsequently.
It was
because
sent subsequently, so
subsequently.
yes, I'm. If we go to the context of the letter, it is with regret that circumstances necessitate our office to approach you in this regard again. We refer to our...
Just a minute, sorry. I'm sorry to intervene. Mr. Mokgoro, I know you want to face Ms. Bawa when you respond to him.
Yes.
I know. Thousand apologies. When you want to respond to her, no, you want to face her. But please, as you do that, kindly ensure that you speak into the mic. And you speak louder. You remember, you surprised yourself that you have a big voice. Just use that big voice, because we would want to capture your responses as clearly as possible in the record. Our technician is complaining that you are not loud enough. Okay, thank you.
The letter starts off by saying, we refer to our representations handed to Advocate Mokgoro during a meeting held at the office of the National Prosecuting Authority during or about February 2012. A copy of which representations is attached here to for your ease of reference, marked GSL1. Do you see that, Advocate Mokgoro?
I see that.
Do you recall that you had a meeting during February and written representations were given to you?
No, not in February. The representation I recall, it was in sometime in April.
Let's move on in the letter and it might clear up for you. In consequence of the representations and the meeting held with Advocate Mokgoro, the reply received from Advocate Mokgoro dated 8 March 2012, the contents of which is self-explanatory, is attached here to marked GSL2. I unfortunately don't have that letter. And I don't know what that letter would have said. Do you recall, let's pose the question differently. Do you recall having received the written representations attached to this letter?
You know, I received representations, as I'm saying, I recall it was in April. When I received these representations, and I had a file, a special file that I prepared on that. I do not recall whether I took the copy of the representations that I received from them as part of that file, but I don't think so. I don't remember.
And you kept this file in the safe in your office. Would that be correct?
I kept that file. It was in the safe in my office.
That is the safe that was sealed when you were removed from your office, correct?
That is a safe that was sealed when things were removed from my office.
And those at the NPA then subsequently opened the safe and removed those documents.
Quite correct.
And when it was given to us, it was told that this was one of the documents that came out of the safe, but I don't take it any beyond that because I can't verify that.
I don't know. I don't know.
But if one looks at the letter, it says in the next paragraph, it made representations on the meeting. It talks about a reply that is self-explanatory. And in the next paragraph it says, further to aforementioned, it has become apparent that the investigations by members of the SAPS had not stopped and has in fact intensified. It has come to our attention that Mr. John Appelsamy, who previously submitted an affidavit, had once again been approached by Colonel Rulofse and Advocate Jerry Nell to become a witness in terms of Section 204 of the Criminal Procedure Act. Do you know anything about that, Advocate Nomgcobo?
I don't recall this Appelsamy.
It then goes on, it is concerning that these investigations are encroaching on national security as the backstopping techniques used for combating international terrorism are being investigated and will ultimately be exposed, which in turn will cause an embarrassment to the Republic of South Africa on an international level. The seriousness of the matter was explained in detail to Advocate Nomgcobo in a meeting aforementioned. Do you recall such an explanation being provided to you at the meeting? Set aside the date for the moment.
We had a lot of discussions about a number of matters.
So is that a yes or a no?
That's yes.
Full details pertaining to this matter cannot be reduced to writing, and therefore we request that your office make a security-conscious decision on the matters currently being pursued by Colonel Rulofse from DPCI, the Acting National Commissioner, SAPS, together with his investigation team, and Advocate Gerry Nel from the NPA. Do you recall such a request being made?
I don't know specifically. I can't recall now exactly what was said. But there were a number of issues of serious security concerns that were raised, during that meeting.
They then draw your attention to the Secret Service Act, the measuring tools for the Secret Service Act, and they provide you with the presidential approval as Annexure 3, which I also don't have, and your attention is then drawn to that provision. In the last two paragraphs it said, our clients are being placed in a position where they will not be able to remain silent much longer as they are being falsely accused publicly, and is now being placed in a position where they will have no alternative but to divulge the true state of affairs in public in order to defend themselves, but it will be to the detriment and embarrassment of the country at large. In the premises as set out above, kindly advise whether you will entertain a further meeting with our clients in order to discuss this matter. How many meetings did you have with them, Advocate Nomgcobo?
I only know the meeting of April. That is the meeting I recall.
And so you say you did not have a meeting with them in February?
I don't recall the meeting of February. At least my file, because I had a file on this. If I had my original file, at least I would be able to confirm that.
Right. If we take you to the presentation, which is attached to it, marked GS L1, in the document. You would certainly receive this.
I am not so sure whether this is the same document that I received, because I took notes, I took extensive notes on this, and I did not attach much documentation because they refused to, they just showed me some documents. They did not show me most of their documents that they had in their possession at the time.
Mr. Mokgoro, can I understand this? This letter refers to a meeting, there might be an issue about dates. It then goes on to say, we are attaching GSL1, and you are saying at no stage did you receive GSL1.
Chairperson, I cannot say because I did not take much documentation at the time, because they had big files that they would show me to go just to peep through. I don't know whether I might have taken it. If I did take it, it could have been in my original file.
Documentation is what is called an Nomgcobo timeline. Does this look familiar to you, Advocate Mokgoro? Is it your handwriting on the second page?
That is my handwriting.
Is it that handwriting yours as well that says threat of media on the first page?
Yes.
That is consistent with what you said Advocate Breitenbach had indicated to you when she came to see you on the 26th, correct?
That is correct, Chairperson.
So, according to this, these representations were reached you on the 23rd of February, and if you look at the last page of these representations, albeit unsigned, it's dated the 22nd of February from Estelle Killian Chambers Santon. Is that the name of the council you recall coming to see you?
I think it was, I'm not so sure whether it's the same council. I don't recall, because it was, to me, it was like a strange name, like this Sinra Lewich. Yes, something like that. It looked like the council also had a similar.
You must try to give the correct pronunciation of the names.
The attorney's name is Etta Zendravich, spelled Sjyndralewicz for the record.
Thank you, Ms. Bauer.
Now, let me take you through the annexure GSL1. I want to raise certain salient points with you. And unfortunately, the pages are not numbered, so we'll just go through them. On the second page, on the first page in the third paragraph, they detail the representations that had been made by General Mluli, and in fact, which they didn't do in the representations. They identify Lieutenant Colonel Viljoen and Colonel Roelofse as those whom they blame as abusing the criminal justice system, correct?
Yes, that's what it says.
Right. In the next page it says, despite the fact that instructions were given to withdraw criminal charges against Lieutenant General Mlula and Colonel Barnard, the investigation has continued unabated. You see that on the second page?
Yes, I see that.
They then deal with the background, and I don't necessarily want to take you through the background just for time constraints, but if you skip 2 pages on, which would be the, oh sorry, it is numbered. My write-up version is not numbered, it's page 33. My apologies. The second paragraph on page 33 says, it is the purpose of this presentation to protect the paramount important fact that members included and subjected to the investigation by the DPCI should not be pressurized into exposing such functions under any circumstances. It is furthermore important that management afford the necessary protection to all members associated with the Secret Service. Do you see that?
Yeah. Yes.
So effectively, they're coming to you, they're making representations, and they don't want the members to be subjected to this investigation. Is that a fair interpretation?
Well, that is a fair representation, yeah.
I'm not imputing it to you, Advocate Mokgoro. I'm simply interpreting the
Yes, I
document.
understand.
Two further pages on to 35. And I want to take you to the third paragraph. The accounting officer, therefore, being the divisional commissioner, has authority over the functioning of the account in terms of policy, the account being the Secret Services account. All expenses, therefore, were undertaken and assessed in terms of the policy in place, reviewed and audited by the Auditor General, were produced, discussed and tabled at the joints. There were no negative resolutions from the GSCI, and resultantly, there is no basis for any investigation to be continued at this point in time. Do you see that, Advocate Mokgoro?
Yes, I do.
Next it says, an important departure point is to categorically state that the policies and procedures of the open account and normal departmental policies and good practices cannot be applied to the Secret Services account, which is the next paragraph. They then impute malefides to the investigators from the top hierarchy at SABC that is seeking to investigate it, and they draw your attention to the Secret Services account on the next page. And then I want to take you to the last paragraph on that page. It is of great import to take account of the fact that intelligence is unlike any other environment. It is unique and operates in a sophisticated manner. This is in keeping with professional standards and best practice associated with other sister organizations and associated. And then they go on and they deal with how the investigations must happen. And they talk about the current investigations. We take you through that. On page 41, I think, at the top of the page of 41, they say the uninformed, the likes of Colonel Roelofse, are now acting out of control when they discover what seems to them on the face of it as a crime, but in truth are necessary methods to successfully execute the mandate held by the intelligence services is clear. The danger that this uncontrolled, uninformed investigation is posing will be divulged to the reader hereof in person with sensitive information that will not form part of this written representation. And I'm going to put to you, if one follows the chronology of the paper, that you initially received written representations. It was then followed up precisely by oral representations, which to the best of your recollection is in April. What followed those representations is your meeting with General Dramat.
What I recall vividly in my mind is that it was in April when I received, I actually sat physically in my office, but I can't recall the exact date. I did not have many people in my office who visited me. I know that previously I used to receive calls about people want to make representations on these issues and things like that. But what I recall is that it was actually in April when I sat down. That's why I'm saying my file, my own file, with my own notes would have been able to help me in terms of that.
But Advocate Mokgoro, in the concluding paragraphs, they say on page 42, the reader of this representation is implored, the reader, as I understand it, to be intended to be you, to take the necessary and required steps to put a final stop to the investigation and request the return of all unlawfully seized documents. The purpose of the representation, as opposed to following the route of approaching the court for the necessary relief, was carefully considered and decided against taking into account the risk of exposing state secrets in open court in order to support such an application. Your favorable consideration of this representation is appreciated. Did you discuss these representations with the acting NDPP at the time?
No, I never discussed the representation with the acting NDPP. I don't know whether I did advise her of this, but I don't recall.
And you will see that the letter of the 31st of May 2012 is addressed both to you and her, and it says delivered by hand.
As I'm saying, what I recall vividly, it was the meeting in April that something was, that the lawyers in question came to me and discussed a number of things. I took copious notes of their presentations.
But it seems as if this was an obvious attempt on the face of it to influence a decision to prosecute. Would you agree?
No, naturally it is, yeah. But yeah, I don't know the result of these representations. My file, for example, would have to disclose what we actually decided or what we did, what I did with that.
You can't remember what you did with it.
I cannot recall what I did with that, but it's only my correspondence file that I kept that could help me.
And you still have that correspondence file, Advocate Mokgoro?
I don't know.
Because you've been able to find things on your computer.
You know, the things that I was able to find were things that I managed to save, like I would go to I had memory sticks, I had a small external drive, so I had to scavenge through those and manage to save, or rather to get a few things of that.
Effectively, this whole notion of putting the Secret Service beyond investigation is very evident from this documentation, correct?
Yes, I understand, but the point is, I don't know what happened to these representations, and I know they may be construed as attempts to do that. But my point with the case was to say, guys, regardless of anything, let's do things properly. That's all my idea was about the matter.
Can I just understand what you're saying, Mr. Mokgoro? You do not know what happened to the representations, the
Chair-
document or what was made of the representations? What is it that you don't know happened?
Because I recall after meeting with these people, I sat with these people, I talked with them, I took copious notes, and then I said I will come back to them. I don't know whether I did or I did not. I cannot recall.
You see, I'm going to put that the contents of your letter of the 26th of April is informed by the information which is provided for in that letter, as you confirmed in the disciplinary inquiry, Advocate Ringgraf.
Naturally, because I received information from various sources, even this one, because some of the information was provided verbally, verbally.
But it does become dangerous when you start taking these decisions on information that is provided to you without any form of verification. Don't you agree?
I don't know when you say taking decision, what decision that is, because the decision is one. The decision is that this matter must be properly investigated with the assistance of whoever can assist us, including the AG or the IG. I don't know what decision.
You see, Advocate Mokgoro, in your letter of the 26th of April, you say, having been provided with further information on the matter and having been privy to other classified, confidential and high-level discussions with police management, I am concerned that our actions in the matter may be interpreted, justifiably so, as amounting to serious abuse of the legal process and as being motivated by ulterior purpose.
That was a warning that I was giving. Let's just avoid that situation if possible. Let's let the police and the IG or whoever deal with the matter, the docket will come to us. Once things are done, let's avoid to dirty our hands.
The above view conclusion is in addition to considerations of absence of admissible evidence, and I'm putting this to you
That is
because
the
it's
point.
fair, and a situation where any evidence that may have been admissible has been compromised. And you get that. It is a known fact, and that known fact you could only have gotten from your visitors. Do you agree?
I got that information from them as well. I agree with that. I got that from them as well.
Because you go further and you say, are the police and prosecutors now questioning the integrity of these institutions? I do not think we have that authority, and in any event, if we want to go that route, we have to do it in a legal and proper manner.
Yes, we have to do that in a proper and legal way.
So you accepted, based on what you were told, that in effect the Auditor General had found nothing untoward.
That is the information I had.
And it is then in the following paragraph, it is my considered view that it will therefore not be in the interest of justice for the NPA to be further involved in this matter.
Let's wait for the police to do their job. That is the essence of my view. Let the police, the AG, IG, whoever can help us. Let's not, because of other information that I received. It was not the only information that is being referred to.
Did it not concern you that the very people who could have been the subject of the investigations within crime intelligence was coming to you secretly to tell you they must back off from this investigation?
No, I did. Fortunately, I did not give any instructions to anybody to back off. The investigation were going to be done by the police. Nobody was going to back off. The point is that question of admissibility of evidence, we must ensure that we don't dirty our hands. There were lots of allegations flying around, during that time. I said, guys, let's not get involved in this. Let's not get involved in this. Let's rather stay back. Let's be clean, because there were lots of allegations. Everybody accusing this one, everybody accusing that one.
Did you have any conversation with your prosecutors about these accusations?
The only conversation that I had with my prosecutors was when they delivered that letter from the IG on the 26th, when Advocate Breitenbach sort of said, what do you think the media would do If you don't, I then ask her, who is going to provide this information in the media?
You're
That-
told there's a prosecutor Y that's doing all kinds of unlawful stuff.
The prosecutor was mentioned, and I don't want to mention the name.
And let's forget about the name for a moment. Did you bring that to the attention of the Acting National Director of Public Prosecutions?
I thought it was not necessary, you know.
You get told of a prosecutor
Yeah,
doing
yeah.
unlawful activity and you don't think it's necessary to bring it to the attention of the boss.
It was an allegation. It was an allegation. I don't want to unnecessarily cause panic, you know. It was an allegation, but I felt, despite the fact it is an allegation, it was not supposed to arise in the first place. Unless, of course, somebody was insisting that it's becoming unacceptable then, but it was just an allegation at the time. But
The entire submission are just allegations, aren't they?
yeah,
Advocate Mogatla testified that you had told her Breitenbach had been given 2 weeks to investigate and revert, and she didn't do so.
I have no knowledge of that. Our agreement with Advocate Breitenbach, the decision contained in this matter is in terms of the agreement of the 9th of December, the matter is provisionally withdrawn. There was no timeline to say within 2 weeks, so much time. There was no timeline. I think she must have been mistaken about that.
That wasn't put to Advocate Mogatla when she gave evidence.
I am saying it now. I know it was not put to her.
It becomes very difficult to expect a comment back from her when it's not put to her. Do you accept that, Advocate Mokgoro?
Yes, if I was cross-examining her, then maybe I would have put it to her. I did not. Yeah, I understand, you are right. It should have been put, but point is, it's not correct.
Do you accept that this investigation of Jenny Mluli was a high-profile matter?
Indeed, it is.
There were serious allegations about a very senior policeman.
Absolutely, it is.
And you were the head of the commercial crime unit. Wasn't there some obligation on you to stay on top of the investigation?
Staying
Or
on
to
top.
keep track of the progress, to get regular feedback on the matter?
No, there are senior prosecutors there. On all the matters, for example, all the high-profile matters that you hear about, I don't get involved. I don't get involved. Excuse me. I don't get involved. I only receive reports. I only get involved when it becomes necessary, like in the case of representations.
Wasn't this slightly different?
It can never be different.
Well, it is slightly different. I'll tell you why it's slightly different. The very regional head who's overseeing this investigation is the subject matter of a disciplinary complaint. Would you agree? At the very same time this is going on.
This had nothing to do with Mluli's case.
No, let me put the proposition to you. Do you agree she's the subject matter of a disciplinary complaint?
I don't know to say if she was a subject matter, because as far as I know, she was a subject matter of investigations.
Investigations in which you were charged with looking at that report, and in respect of which you made a report with recommendations.
I made recommendations.
Right. Those recommendations was based on your impressions and your views after perusal of the files, correct?
Yes.
So in your view, at the time, the very prosecutor who was being charged to oversee this, there was prima facie evidence of serious misconduct, and in your view, there was prima facie evidence of a crime of defeating or obstructing the course of justice. You in fact suggested and recommended an internal disciplinary inquiry and the institution of a criminal investigation. You recommended that she be suspended with immediate steps to be taken to safeguard evidence, the implication being that you were concerned she would get rid of evidence, and that you recommended that she be the subject matter of criminal charges. And you make that recommendation a month after she is charged to go and oversee these investigations of the head of criminal intelligence. And it is based on that that I'm saying to you, does this not constitute exceptional
No,
circumstances?
it does not. It does not.
It is so that the only time a step is taken further to appoint somebody to investigate that is when you address a letter to Advocate Marshall in August of that year, correct?
Can you come again, Advocate Bauer? You say it is the...
Let me do this chronologically. We were now at April when you wrote off this letter.
Yes.
Nothing is happening in the investigation. Advocate Breitenbach is suspended at the end of April. And the first step that is taken by you is subsequent to the meeting with Advocate Dramat. And you then write an email or a note of, it's easier, we have it to, and I must pronounce this properly, Advocate Marshall Mogatle, where you tell him he must appoint prosecutors and he must appoint somebody other than Advocate Ferreira.
Advocate Bauer, I had no reason at all to believe that the prosecutors or anybody else, is not doing anything about this matter. And as you will recall, that soon after the delivery of that memorandum by Advocate Breitenbach, about 8 or 7 days thereafter, there was an application by FUL to review the decision. By that time, we got absorbed into preparations for that because I would be called to give this information and that information. It's only after I was advised of the request of of General Dramat in August that we advised General Dramat of what the position is as I understand it in respect of the matter.
But you were well aware. And what was your reason for asking for Advocate Ferreira to be removed as the prosecutor?
When did I do that?
In the communication to Advocate Marshall
yes.
Mogatle, where you
yes.
say appoint new prosecutors.
Yes. You know, one of the reasons was that I could not understand this behavior because she was always with Advocate Breitenbach. Even by the time I was threatened with this media exposure, and in any event, it was starting to come out during that time. And some of the things that I've received during these briefings, to me, were not. It was important that we have people that will look into this matter afresh.
Did you feel that Advocate Ferreira required some sort of an explanation?
I had information, I had information as well that they were meeting some other outside parties, giving information and things like that. So I was not comfortable with that. In case it turns out to be true, I would have been warned. At least we have got prosecutors.
I thought I had asked, sorry to do this to you, I thought I had asked us all to switch off our cell phones. We're disturbing the proceedings. Kindly. Thank you. Pardon me for that interjection, Mr. Mokgoro.
Thank you, Chairperson.
You may proceed.
Sorry, you were saying that you had heard stories?
As I'm saying, I was giving this information. I was getting also this information about leaks was about, because information was starting to leak in the media, and from preliminary reviews, it became clear that that information could be traceable to a number of sources. And in one of the meetings I had with, I think it was when I had a meeting with an official in the National Commissioner's office, that I got information that some of your prosecutors are involved in leaking information to outside parties, are engaged in discussion with outside parties. But for me, that was that was one of the reasons that I had in mind.
And was your information that Edward Ferreira was the person doing that?
No, not necessarily the prosecutors involved in the Mluli matter.
But he was the prosecutor involved in the Mluli matter.
Yes.
So the implication was that you had been provided with allegations that he was leaking the matter.
Yes, well, that could be I could put it like that, yes. Because I knew that we've got capable prosecutors who could deal with this matter properly, as well as they would have done as well. But it became clear after the meeting of General Dramat that nothing was happening, because that is what I could not understand, despite the understanding that this matter was supposed to be proceeded with. Nothing was happening.
Did you ask him?
Advocate Bauer, I don't think I did. I did not ask him. Let me put it like that.
See, Advocate Mokgoro, I'm reminded of what Advocate Jiba said yesterday, and it is a valid point. From the lowest prosecutor to the highest prosecutor is a preservation of independence. Here you remove a prosecutor from a case without providing any explanation to him other than what you have heard as allegations, and you remove him from the case.
Yes, I would say I did, because I made a request to the regional head of the SCCU to say, following the meeting with General Dramat, it would be better, so that we are seen to be not to be biased or in favor of any other person, and then let's get new prosecutors in this matter.
Without providing him any Audi, any hearing.
I don't know whether I was supposed to do that in the operational environment. I don't know whether I was supposed to do that. If he would have requested reasons, naturally I would have provided him with reasons.
You're the senior supervisor, and this is an employment environment, correct?
Yes, as I'm saying, I had my views about the importance of how we need to handle this matter as clean as possible, So I had these allegations, so it was important to me to suggest to the regional head if we can appoint as, people who will not uncontaminated in the sense that the allegations that are being thrown at them, So that was my idea.
He should be afforded an opportunity to answer those allegations.
I would have thought the regional head, who's his direct supervisor, I was not his direct supervisor. His direct supervisor maybe would have thought it would have done that, but if he wanted reasons, I would have given them. If he said to the supervisor, what are the reasons from Advocate Mokgoro, then his supervisor would say, let's go back to Advocate Mokgoro. He did not do that.
Did you share your reasons with the supervisor?
I don't recall. I don't recall sharing, because I wrote him a letter. I communicated with him by correspondence.
You see, can you then blame them for thinking that for some nefarious reason they were removed?
I don't blame him for complaining that he was not given reason. To attribute ulterior motives to me, I would not agree with that.
Let me take 3 further coincidences which Advocate Breitenbach raises. she says, shortly after she brings the Inspector General's memorandum to your attention, which is roughly around the end of March, beginning of April, a criminal complaint is laid against her. That's how.
I am not aware of that.
Two, she says that the timing of her suspension is the same week as when she lays the document at the doors of the acting national director and by you.
If I may complete this sentence to say I'm not aware of any criminal complaint against Advocate Breitenbach. What I know, during 2012, a number of complaints started flooding in from the Hawks themselves against Advocate Breitenbach. And that led me to look into those matters, to sit with those people, and they continued. I don't know about the criminal complaint that you are talking about.
Well, the criminal charges were laid. The criminal proceedings commenced after the disciplinary inquiry sometime later. And, no. The timing might be wrong because that criminal complaint related to. No, let me take that.
It was some other time, because during my time we received a number of complaints about a number of cases that were actually swept under the carpet in circumstances that suggested, so we continued with those investigations. We continued with those to look into those matters. Otherwise, with a criminal complaint, I'm not aware.
Sorry, I took this from record page 297 of the transcript in the disciplinary inquiry, where Advocate Trenger, this is on the 30th of March, this is the letter. Within days after that, Mr. Gloucester lays a criminal complaint against Advocate Breitenbach on the 10th of April. And you responded fairly to say, I'm not aware of that.
I was not aware of that because I think I do Mr. Gloucester, but I can't place him where he used to be. But I think it was within the IM. I don't know.
Can I turn off the? Would you like to take a break? Advocate?
Can we make it a lunch break? An early lunch break, then we come back 15 minutes earlier? No. So
And we come back at 1:30. Would that work? It's 1:45 now.
Yes,
Can I
45 minutes.
The only issue is, I don't know, can I say this off the record?
I think we can. Now, I was going to suggest that I think we can have it within 45 minutes.
I don't know. How do you do this?
Yeah. Can we come back at 1:30? Thank you.